Healthy Snacks Meals in the building.
I wasn't even thinking about me being on the show. I wanted to produce something for them.
Celebrity. Like if I went to the mall and stuff, people are like,
The thing was, I didn't even know that anybody ever thought I was ugly.
We look like twins almost.
Okay.
She really wouldn't be
Covering any more subjects related. So that's why you got the raw reaction. This is pathetic. It's pathetic. Okay, guys, welcome back to another edition of the Sweet Pea Diaries. It's your girl, Sweet Pea, and I am back with another video. If you are a returning subscriber, welcome back to the channel. And if you are a new subscriber, welcome to the Sweet Pea Diaries. Be sure to like this video, share this video, but most importantly, be sure to subscribe to the channel. All right, so who we got in the building? We've got Tiana the polar bear. She was here first, and she took out her folding chair and sat down, pulled up and said, I'm here, I'm here. Alice Morris, hey girl. Miss Gardner for President, Hubbard Lalis, T the Goddess, Netta 24, Sunshine, Cocoa Butter Barbie, Monica, of course, and Latanya. Hey, I got everybody that is here so far. Okay, so I'm sorry that I had to stop the live earlier. Child, one of my children's, they was having some issues with the Uber, and I thought my children, my oldest daughter, I thought my baby was missing. I couldn't get a hold of her, and she wasn't outside for the Uber. And come to find out, honey, she had done got on the bus and went home. So, yes, you know how mommies do. If we can't find our children, honey, everything got to shut down. So I had to shut this thing down until I found my baby. But all is well. Everything is fine. So, yes. So now I can do this live in peace, because if I did not know where my baby was, I wouldn't have been able to read no court records. I wouldn't have been able to make no kind of jokes or anything, because I would have been thinking about my baby. So yes, everything is good. So now we can get into the mess. Now, we did the update yesterday on the petties, and something struck my eye. I didn't have time to really get into it because we were already 2 hours in. So I was like, I'll save it for a separate video. But we know now that Kenneth Petty, he had finally responded to the lawsuit. But I keep telling people, this is not an official response. This is just another half-ass excuse as to why they're late in responding, and they still have not responded. I keep telling people they still have not responded. They are just begging for more time to respond. They are responding to these defaults for judgment that Jen is asking be granted. That's what they're responding to. They have not officially responded to this lawsuit, which is why Jen is asking to win by default. When you do not answer to a lawsuit, they issue a certificate of default. The clerk's office, it is a certificate that states the person being sued has not properly replied to the lawsuit, answered to it, said what they intend to plea. So you missed your deadline. It's sort of like a judgment when you go to court and you have some type of judgment against you. If you don't go, they will find in the person's favor that is suing you. So that's sort of like what this is with Jen. She is asking the court to issue and to award her a certificate of default for Nicki Minaj because she did not answer to the lawsuit in time either. And they are asking that the certificate of default that they already issued for Kenny, that it be honored and that she be allowed to win this case based off of him being late. Nicki Minaj, I'm not sure if they are going to allow Jen to enter the default judgment certificate for her because she applied for it, but it was not done. Remember, the court's office said that they had not enough staff. They didn't have enough staff on hand, and so they weren't able to issue the certificate and do it because there wasn't enough people on staff. So Tyrone's argument was that we don't got nothing to do with that. Nothing of that nature should affect my client's default certificate. You need to go ahead and issue that, and she needs to win on both default judgments for both of these defendants. So that's what is being argued right now. We do still not have an answer to this lawsuit. Neither one, Kenneth or Nicki, they have not responded. So that was something that I wanted to clear up in the beginning of this video, that what we are waiting for is still a proper response. It just goes to show you that when you are a celebrity and you have high-priced attorneys, you can get away with other things that normal common folk cannot. Had this been anyone else, they would have issued the default of judgment and she would have won, period. But because this is a high-profile case, it is Nicki Minaj. They are working with lawyers that got money, that got connections, that know people. We are still here. We shouldn't be here. Jen should have won. It should have been over with, and we should go on to live another day. However, they're going to be, going around in circles and playing around with this thing because they have money. That's just how it is, unfortunately. But I noticed while we were going through these documents and we were reading Kenny's declaration, we noticed that Kenny is now stating that he did not do this, that he did not R-word Jennifer, that it was consensual, that Jennifer and him, it was a consensual hookup. He never did this. So he is now actually saying in this brief that he did not do this at all. So we went from consensual to he didn't do it. Or did we go from I didn't do it to consensual? Let me know in the chat by a 1 or a 2 if you were paying attention yesterday. I need to know, 1, did we go from, if you put a 1 in the chat, if we went from I did not do it to consensual, or put a 2 in the chat if we went from consensual and I did not do it. Which way did he say it in this brief? I'm going to count it down. Again, put a 1 in the chat if the narrative in the brief was I did not do it to consensual. Put a 2 in the chat if it was consensual to I did not do it. Okay. So we only had 2 people that participated. T the Goddess said a 2 and Monica said a 1. So that's even. So T the Goddess says it went from consensual to I did not do it, from I did not do it to consensual. So it's 2 of them. T the Goddess and Maya said it went from consensual to I did not do it. And then Monica says I did not do it to consensual. Well, now we're going to look at the document. And I'm going to show you exactly. Because when you put something down on a court document, you're actually swearing to it, okay? You are swearing under the penalty of perjury. You are swearing, meaning I am saying that these are my words. And if I'm lying, then perjury will be my recourse. If I'm not telling the truth, the penalty is perjury. And whatever consequences come with perjury, let that be my fate, okay? So anytime you make a statement in a court document, you are saying this is true, all right? So keep that in mind. So yesterday, we read Kenny's declaration and, answering to this default. He's basically saying he does not want Jennifer to be awarded this default. Her lawsuit is without merit. And the reason why she's rushing to a default is because she knows she cannot win. She already knows she can't win. So because she knows that she can't win, she wants to hurry up and win by default. Well, she gave you time. They gave you a deadline. You did not comply. So usually when you don't comply, that's the recourse. Well, this is what was said on the document. Now we remember. All right. All right. Okay. So, defendant has demonstrated meritorious defenses. The second factor a court must consider in deciding whether to vacate a clerk's certificate of default is whether the defaulting party has a meritorious defense to the claims against it. The test of such a defense is measured not by whether there is a likelihood that it will carry the day, but whether the evidence submitted, if proven at trial, would constitute a complete defense. The defaulting defendant need only meet a low threshold to satisfy this factor. A defaulting defendant's allegations are meritorious if they contain even a hint of suggestion, which proven at trial would constitute a complete defense. Plaintiff's argument, Jen's argument, that the allegations in the amended complaint are deemed admitted due to the entry of the certificate of default, and that for this reason, defendant is unable to demonstrate a meritorious defense, is without merit. If this were the case, no defaulting defendant would ever be able to demonstrate a meritorious defense. This is not the law, and the cases relied on by the plaintiff concern situations in which the defendant did not oppose the motion for a default judgment, which is not the case here. Now, indeed, Kenneth Petty has more than satisfied the low threshold required for demonstrating a meritorious defense. As discussed in the Petty Declaration, defendant was not convicted of R-ing plaintiff in 1994, 27 years ago. He pled guilty to and was convicted of attempted R-word. Defendant denies that he ever R-word the plaintiff, and defendant denies all of the plaintiff's allegations of improper conduct or sexual assault. Rather, the sexual encounter between plaintiff and defendant was consensual, and plaintiff was a willing participant. Defendant pled guilty to attempted R despite his innocence because he was a scared 16-year-old kid and was told that his sentence would be 20 years to life if he did not plead guilty to attempted R. Now, we're getting ready to break all of this down. We're getting ready to show a few things and really actually make you guys can come to your own conclusion, and you can draw your own conclusion from the facts that I'm about to present, okay? I don't want to be the one. I want to lay it all out, and I want people to make their own decision and as to what they see. So I'm going to read it again, and you tell me which way did this go? One or two? Plaintiff's argument is that the allegations in the amended complaint are deemed admitted due to the entry of the certificate of default. So she's saying, I need to win my argument because the clerk gave me a certificate of default. So I need to win this lawsuit against Kenny because he did not reply on time and the clerk issued me a default. But Kenny is saying that he did not do this. He is saying that he was convicted of attempted R. He was not convicted of R. And that in this amended complaint, Jen is not saying that the defendant attempted R'd her. She's saying that he R'd her, that he downright R'd her. So the lawyer is saying that none of this happened because what they did together was consensual. So if he's going to say on one hand that he didn't touch her, there was no contact, but then he says the encounter that they did have, it was consensual. So which one is it? You can't say that you never had an encounter with someone, but then say that you did, but it was consensual. So which one is it? You can't say that you did not R someone. You weren't convicted of R, you were convicted of attempted R, but then say you want the charges thrown out because you never touched the person. But you just admitted that the encounter you had was consensual. So in order for it to be consensual, you had to have done something. I'm going to let that sink in. As discussed in the Petty Declaration, defendant was not convicted of R-ing the plaintiff in 1994, 27 years ago. He pled guilty to and was convicted of attempted R. Now, here is where the attorney is going to try to play the game. He's going to try to play the game with the wording and try to persuade the judge and others to believe that he never was convicted of R. He was convicted of attempted R. So that must mean that he didn't do it because they attempted R'd him. They gave him attempted R. So that must mean that they knew that they couldn't put him in jail. They wanted to railroad a little 16-year-old boy. The state of New York wanted to railroad a 16-year-old kid for what? What does the state what do they stand to gain out of this? There was no white woman assaulted. There was no white child assaulted. There was black on black crime, okay? Usually when they're railroading black boys, young black boys, if we want to go with that narrative, there would be a reason for it. There would be a reason to railroad a young black boy. A young black boy assaulting another black girl, a mixed girl, whatever, from the same community. They want to railroad him for that. They want to railroad him for that. So he has stated, as discussed in the Petty Declaration, defendant was not convicted of R-ing the plaintiff 27 years ago. He pled guilty to and was convicted of attempted R. Defendant denies that he ever R'd the plaintiff and denies all of the plaintiff's allegations of improper conduct or sexual assault. Rather, so he's saying all of this that you just said, rather, but the sexual encounter, instead of all of this, rather, instead, the sexual encounter between the plaintiff and defendant was consensual. And the plaintiff was a willing participant. So how can you say that you didn't touch her? Because he's going to go down farther into this declaration saying that he didn't touch her. That he didn't touch her. They had no contact. But you just said, rather, the contact that you did have, it was consensual. Make that make sense. Make that make sense, people. Defendant pled guilty to attempted R. despite his innocence, because he was a scared 16-year-old kid and was told that his sentence would be 20 years to life if he did not plead guilty to attempted R. First of all, Kenny and character witnesses and people that knew him from the neighborhood, and even, excuse me, y'all, I got to eat a couple of these scoops. I'm hungry. Give me a moment. Give me 1 second. So, if you did not have any type of interaction with her in that way, sexual, and you didn't R her, you didn't attempt it R her, you didn't do any of it, how do you come back in that same paragraph and say, rather, the sexual encounter between the plaintiff and defendant was consensual, and the plaintiff was a willing participant? And the only reason why he pled guilty is because he was a scared 16-year-old kid. According to the defendant has demonstrated a meritorious defense concerning count 1, intentional infliction of emotional distress, count 2, assault and battery, and count 3, sexual assault, New York, of the amended complaint. These counts are all based on the alleged R of plaintiff, which defendant denies occurred. In addition, as defendant denies he R'd the plaintiff and did not plead guilty to R, counts 1 to 3 are barred by the statute of limitations, which is 3 years. So they're saying, even if he did do it, the statute of limitations has run out. Although the alleged R occurred in 1994, plaintiff claims that these causes of action are timely, relying on Section 214G of the New York CPLR. And so AM Company, whatever, trolls the statute of limitations for every single civil claim or cause of action brought against any party alleging intentional or negligent acts or omissions by a person for physical, psychological, or other injury or condition suffered as a result of conduct which would constitute a sexual offense as defined in Article 130 of the Penal Law committed against a child less than 18 years old. So what they are saying is the statute of limitations has run out on a normal attempted R, charge, right? But they're relying on this other law that is in place for crimes that happen against children that are a sexual offense or physical, psychological, or injury that was suffered as a result of conduct that was sexual in nature. So there is a law that encompasses such things, and it doesn't have a statute of limitations. So that is what Jen and her attorneys are using, that law, to try to get some retribution as to what happened to her back then with Kenny. Because the argument is that now that Kenny is with Nicki Minaj and she has money, Jen is now able to sue. All right. They're now, they have money, Kenny's with, and so she's able to sue. Well, if that's the case, it would make sense. Because if I couldn't get nothing from him before, and now that he's married to a millionaire and I'm able to get my just due, why would that be so wrong of her, especially that she is the victim? And the fact that they are continuing to harass her directly and indirectly, because we've now just found out with the documents that Kenny is admitting that he knew Black, that Nicki Minaj has talked to Black. He has admitted to giving Black Nicki Minaj's phone number. Why would you give your wife's phone number to Black? Someone that is in the streets, someone that she doesn't even know, but you know. Why would you give your wife his number? I don't get that. Or why would you give him the number? Makes no sense. Nicki is like I said, a worldwide celebrity. She's all over. She's everywhere. Why would she want a number of a known gang member, criminal, for what? What would she need to speak with Black about? What would she need to speak with Black about other than something like this? What? For what? You understand? So the argument, you can understand both sides. Now, we can almost believe that, right? We can almost believe that. We know how governments try to railroad our young boys. We know how, the system tries to railroad our young Black men. We can almost believe that. We can almost allow him to use that argument. If it was, remotely true, there wouldn't be other issues that I'm going to point out to you. Okay. I'm going to point some things out to you that's going to show you that this is all cap. This is just all a way to try to get out of this lawsuit. As I told you, when you get a high price attorney, his job is to try to poke loopholes or try to find a way out of the lawsuit. But what they usually end up doing is contradicting themselves and putting their foot in their mouth. Because if you're going to say that Kenneth Petty did not R-word Jen, that they had no type of violent situation, but then you come back and say the sexual encounter that did take place, it was actually consensual. Well, the encounter that Jen describes, it wasn't consensual. This is what the encounter, she describes this encounter. Okay. I am not understanding how you would think this, what she describes, was consensual. Factual allegations. Kenneth Petty violently R-ed plaintiff Hough. September 16, 1994 is a date now burned into plaintiff's memory and soul forever. Plaintiff, a 16-year-old girl, left her grandmother's house in Jamaica, Queens, and was headed to Q7 NTA bus stop on 145th Street and Rockaway Boulevard to catch the bus for school. Petty was standing at the bus stop when plaintiff got there. Petty was known as a delinquent that opted not to go to school, instead choosing to spend his days scouring the streets of Jamaica, Queens. So already this is painting the picture of what type of person Kenny was, all right? Okay? This is painting what type of person Kenny was in the neighborhood. Him being known to skip school, scouring the streets of Jamaica, Queens. Does this sound like a shy young boy that would have been intimidated and the police department would have been able to railroad him into taking a plea for something that he did not do? Okay? Petty was standing at the bus stop when plaintiff got there. Petty was known as a delinquent that opted not to go to school, instead choosing to spend his days scouring the streets of Jamaica, Queens. On September 16, 1994, when plaintiff arrived at the bus stop, she was taken aback at the sight of Petty waiting at the bus stop. Petty's custom is to stand outside the store across the street from the bus stop, not the bus itself. His custom is to stand outside of the bus stop, outside of the store, not the actual bus stop. So he was accustomed to doing this. People were used to seeing him do this in the neighborhood. This was something that he did. Plaintiff stood at the bus stop but did not address Petty. Defendant Petty asked the plaintiff, "Where are you going?" To which plaintiff responded, "To school." "Where are you going?" To which Petty answered, "I am going to school also." Plaintiff did not believe him because she knew Petty never went to school. So she responded, "Yeah, right." After that brief exchange, plaintiff turned her back to Petty to look to see if the Q7 bus or a dollar van was coming. As she turned her back, Petty approached her from behind. Petty grabbed the back of plaintiff's jacket firmly and pressed the knife into her back and told her to start walking. Plaintiff tried to turn around, but Petty would not let her go, nor would he take the knife from her back. Plaintiff began pleading for her life. "Kenny, where are we going? Kenny, please just let me go." Petty did not let her go. He already made up in his depraved mind that he was going to R-word the plaintiff. Petty walked plaintiffs to a house around the corner from the bus stop, not letting go of his grip on her clothing, and with the knife still pressed firmly into her back. Petty kicked the door to the house open, pushed plaintiff inside, and walked her upstairs, still at knife point. Plaintiff was crying the whole way up the stairs, pleading for her life, absolutely terrified of what would happen to her. Plaintiff pled to Petty, "What do you want from me? Why am I here?" Petty replied to her as she pled through her tears, only stating, "You know what I want." Plaintiff ensues in a struggle with Petty, fighting for her life to get this rapist off her. Petty held her down with his body weight and used his hands to forcibly rip off her pants, prying them off her small 16-year-old frame. Plaintiff was fighting back with all the strength she had. Then Petty grabs the knife again, presses it into plaintiff's stomach, causing a small cut, and threatens to use it further. Petty begins to squeeze plaintiff's sides to force her to let go of her pants. After being threatened with a knife cut on her stomach, plaintiff had no fight left in her. Seeing no escape in sight, plaintiff did the only thing she could do to save her life, and that was to give in and hope her rape would be over quickly. Once Petty got off plaintiff, he stood in the mirror, beat on his chest, and stated, "I'm the man, I am the man," repeatedly. Now, this is the description of the event, okay? The reason that I read this is to show the severity of this occurrence. There are elements when a crime is taking place that have to occur in order for you to be charged with certain things, okay? There are certain elements that they have to find you that you participated in and agreed in order for you to be able to be, charged and sentenced. It goes all the way down to your punishment. The higher your crime, the higher level of violence, the higher and severe your punishment will be. The lower level of severity, the lower your penalty will be. Okay? Now, there are certain sex crimes that carry punishable offenses, but not so severe that you have to register as a sex offender. There are plea deals in place where if you have been convicted of rape, sexual, statutory rape, first degree rape, attempted degree and the attempted rape in the first degree, there are different elements to these crimes, okay? And some of these, you don't have to register as a sex offender. So just keep that in mind, all right? So here is the document. This is the original document, the sentence and commitment document that Kenneth Petty signed when he was just 16 years old. Okay. Now, before we show this receipt, has anybody ever seen this receipt? Before we show this receipt, has anyone ever seen the original, any original paperwork from the original case, from the 1994 case? Have we ever seen any paperwork from this case? I could have sworn, a lot of people said that they seen it, they saw, they laid their eyes on it. Have we ever seen anyone do a video and show any paperwork from the 1994 original case? Let me know in the chat. Has anyone seen any original paperwork? I'll give you a minute to respond because I already know the answer to that. But I want to see a show of hands. I want to see if anyone has seen any original paperwork. The answer to that is no. There has not been any original paperwork from that case. No one has it because it's sealed. Okay, that case is sealed. It's a child, it's a case from kids, they were young, 16, 17 at the time. All right. Well, this Kenny went to the courts, their lawyers, and they have the original case. They have the original paperwork. So what they showed and what they chose to show is this document right here. And I found it very interesting that they didn't choose to show what occurred because they're in their possession of the original. I tried looking in the New York courts. I tried looking in Pacer. I tried looking all over the place. The reason why the public cannot get their hands on that evidence is because it is sealed. It is from minors. You can't get records of underage people. You can't. It's not public record. Now, once you get a document and you enter it into a case like this and it's public, then now it's made available to the public, especially now that these two are not minors anymore. They're not minors, they're grown. Plus, this has been entered into evidence and it is on a public platform. So that's a little disclosure. I'm going to, before I get the damn trolls and people saying, oh, well, Sweet Pea, how come you're showing this if it's sealed? Because they have entered it into their case and they're trying to, use this as evidence that Kenny was somehow talked into something. Well, no, he wasn't talked into anything. Actually, this shows that he took a plea deal. It shows that he took a plea. The maximum sentence to attempted rape is 25 years. All right. It is not 20 years. It is 25 years. Just like the lawyers tried to say in their little declaration here, that he was so scared, and he was told by the police that if he didn't make, a plea, if he didn't play ball, he was told by the law enforcement, DAs or whoever, that if he didn't play ball, he was going to do 20 years to life. That's a lie. I can understand if you want to say they tried to threaten you with lies, but that's a lie. And we all know that attempted rape, attempted anything, does not carry a sentence punishable to life, from 25 years to life. No. The maximum sentence for attempted R is 25 years. But when you take a plea deal, they're going to give you a maximum and a minimum. They're going to say, you take this deal and this is what you're going to, you can go as low as a year and you can go as low as 10 years or whatever the deal is that they work out. So take a look at this document right here. This is the original sentence, like the signing of the sentence. Sentence and commitment New York State Supreme Court. Kenneth Petty, the people of the state of New York versus Kenneth Petty, male, aged 16, convicted of the crimes and intermediate term of whatever, prison or whatever. So the defendant, he was convicted of the crime of attempted or in the first degree, which they have given him a sentence of minimum 1.5 years to 4.5 years. So they're saying this was his address at the time, and the remarks that were written on this paperwork from, the court reporter who was filling it out, she put, defendant is 16 years old at the time of sentence, will be 17 on 4/6/1995. So at the time of this sentence, which the date on this was 4/5/95. The next day, his birthday, he turned 17. So that's why it was important that they noted he was not 17 on his day, because the next day he was going to be turning 17. So he was just made it. He was 16 on 4/5. He got convicted and sentenced a day before his birthday. Okay. He got convicted and sentenced a day before his birthday. The next day, he was turning 17. So when they say, well, he didn't get convicted of R, that's right. But there are certain elements that take place in order for you to have to register as a sex offender. So if he had of only it wasn't some violent rape that occurred as the way Jennifer explained it. It wasn't no weapon involved. It wasn't anything like that. He would not have had to register as an S offender. The plea deal that was given to him would have been attempted or maybe even assault. It would have been dropped down much more if there was no evidence of him doing this. If there was no evidence of the violence, if there was no evidence of the R occurring, they wouldn't have dropped it down even more so, and he would have not had to register as an S offender. But because there were certain violent elements that took place, he had to register as an S offender. Usually people that get, convicted of attempted R, they would not have to register as an S offender if it was not violent. And here's some information. This is this is from an attorney's website that specifically deals with rapes and sexual crimes. Okay. So look at what they say about these type of crimes. So the question with this should I take a plea agreement in an S assault case? Understanding every aspect of the offer, you need to understand, prior to accepting any plea agreement, the criminal defense attorney will advise the client on how the agreement will affect potential prison time, S offender registry, and other civil disabilities. In some cases, the accused may be offered a plea agreement reducing a first-degree sexual assault to a third-degree sexual assault. In this scenario, the value of the plea agreement is that the accused was once facing 1 to 50 years for the first-degree sexual assault. They are now facing 0 to 1 years for the third-degree sexual assault. So now, this is where, this is the most important part of this video, all right? This receipt that we're showing right here basically explains how a plea deal works and how criminal charges that are severe in nature, if you bring them down, it will lessen the time of incarceration. However, you can't go from one spectrum to the next. So you have to keep it with R, right? You following where I'm coming from? If you started with if you want to say that he didn't R her, right? Let's just say the argument with these lawyers is that Kenny didn't get convicted of R. He got convicted of attempted R because they knew that he didn't do it. They knew that he didn't do this, so they had nothing else to do but give him attempted R. Well, this receipt is showing you that that's not true. Because if it was attempted R, then it would have been dropped down to what comes after attempted R. Are you following me? They have already attested, his attorneys, Kenny, already attested many, many times that he took a plea. They say in their brief that he took a plea because he was a scared young boy. He was a scared teenage boy, didn't understand the law, didn't understand. He just knew that he didn't want to do 20 years to life. So they were able to talk him into it. Okay, so if that narrative is true, then it would have been dropped down to something other than attempted R. If it started at attempted R, then what did it drop down to? Because when you take a plea deal, it says it right here. A plea deal means that it starts off as the first degree down to maybe the third degree. So it will carry from 1 to 50 years at first to now you're only looking at 0 to 1 years. So if we want to say that he took a plea, where did he start at? He started at R. He started at first degree R, which is why we arrived to attempted R. Okay? He started either at first degree, second degree, whatever it was, but he started at R because it went down to attempted R, which is how we got from facing 20 years to now 1 to 4. You following me? Are we following? If we exchange, so furthermore, this plea offer reduces the charge from a felony to a misdemeanor. While this may seem like a good deal to a defendant whose odds of winning at trial are extremely low, it still carries mandatory S offender registration for 15 years. Now that would be if you did first degree S assault or third degree S assault. So why did these people not charge him with S assault? Why did they not charge him with S assault? If it was just, he didn't R her, he didn't do anything. They had no proof. They had nothing to go by that he did any of this. They just wanted to railroad him. How did we get at R? How did we get at attempted R? Why did they not do sexual assault? Why did they not do sexual assault? Think about that. Why did they not do sexual assault? I'm interested to know what you guys think. I'm asking you, why do you think so? Drop in the chat and let me know. What do you think? Why do you think they didn't do sexual assault? What's the difference? All right. Why are we not at sexual assault versus R? Well, let's take a look. What's the difference between the two? Because when you want to say that this didn't happen, that a lot of these people do this shit, they don't give you no type of, they don't give you no type of definitions. They don't give you no backbone. They just give you their interpretation of things. They don't have a receipt. They just give you their interpretation. I understand that, like I say all the time, everyone feels like they have a personal stake in this. Some people like Jen, some people like Nicki Minaj. But this is about a person's life. This is about Jennifer's life, and this is about Kenny's life, whether you like them or you don't like them. I keep telling everybody, we all have the right to be standing for whoever we stand for. But at the end of the day, people's lives are being affected. This is not a game. This is not, fun and games. You guys out there on social media, y'all might tune into YouTube because you don't have, you just like to be entertained and everything, and you really don't care about what's going on. But there's some of us that really do care. We really care about it, and we really, want to see justice served. So Monica says R is penetration, S assault is everything but, from what I know in my experience, my opinion. Those lawyers know what the deal is. They just go by what he said. They are getting paid. I agree. Exactly. We all have our own opinions, and we are all entitled to like who we like. But at the end of the day, this is serious. This is someone's life at stake. This man had to register as an ex offender for the rest of his life. So that tells you certain things that have been put in place, they are put in place for elements of things that happen. If you have been convicted of a violent assault, you're going to have to register for a certain amount of years, if not your entire life. If you've only been convicted of an assault that was a simple third-degree assault, you may not have to do any ex-offender registry. You might just be in jail for 0 to 1 years. You know what I mean? So there are certain things that you have to do in order to be on that list. Now, here's the difference between being an ex-offender and RN. All right? Actually, sexual assault versus rape. How are they handled and what's the difference? Now, this is according to California law, how they're handled, but this is the difference between the two. To prove a case of sexual battery, there are several things that need to be proven. Well, actually, I'm not going to do this. I'm going to change it because I'm going to get a different receipt because I don't want people to say, well, that's California. That's not New York. So give me a moment. I have a different receipt. Give me 1 second. All right, y'all. So this receipt here, I want to show you as far as New York goes, the type of crimes that are considered sex crimes. All right. Definitions and penalties. Because to be honest with you, there really is not, I don't know how to really say this without there really isn't a such thing as attempted rape. There's not really attempted rape is not really a crime. The actual crime itself is called rape. You got rape in the first degree, second degree, third degree. You got assault and sexual assault in the first degree, second degree, third degree. The whole attempted thing is when they slap that on there when you take a plea. There is no such thing as attempted R. There, that's not a law anywhere. I mean, a crime anywhere. There is no such thing as attempted R. It's not listed. The crime itself is R. So I don't even know why I'm saying R, because I've said the goddamn word rape so many damn times. This video is not going to be monetized. If it is, it's going to be limited anyway. So who cares? I'm sick of saying R here and there because I forget when to say it. And so I'm just going to talk. So the whole situation in itself, when they slap the word attempted on there, it's because you took a plea deal. So they're just trying to get the sentence lightened. And they're trying to make it sound less, less violent, and it lowers the sentence. All right. So in New York, here's their sex crimes. Attempted rape is nowhere on there because that's just not a thing. It becomes attempted rape when they try to, say that we're going to put this plea deal, we're going to say attempted so that it makes, and then that's when the person will say, well, if I got convicted of attempted R, then that must mean I didn't do it. And it's like, no, So in New York, this is how it goes. Rape in the first degree, rape in the second degree, rape in the third degree, sexual misconduct, criminal sexual act in the first degree, criminal sexual act in the second degree, criminal sexual act in the third degree, forcible touching, which is a misdemeanor, predatory sexual assault against a child, course of sexual conduct against a child in the first degree, course of sexual conduct against a child in the second degree, sexual abuse in the first degree, sexual abuse in the second degree, sexual abuse in the third degree, persistent sexual abuse, aggravated sexual abuse in the first degree, aggravated sexual abuse in the second degree, aggravated sexual abuse in the third degree, and aggravated sexual abuse in the fourth degree. Nowhere on here is there anything called attempted R. Okay? Because it is either rape. It's just that simple. Rape in the first, third, second degree. The only reason why we have it as attempted is because he took a plea deal. And you're absolutely right. If it was rape in the first degree, you definitely could be looking at life. You could have been looking at 25 years to life. It was violent. Now, what constitutes how is it defined? Engaging in sexual intercourse with another person by forcible compulsion, or who is incapable of consent by reason of being physically helpless, or who is less than 11 years old, or who is less than 13 years old, and the actor is 18 years old or more. What are the punishments for this crime? 5 to 25 years in prison. And then they just talk about the different types of sexual intercourse. Second degree, being 18 years old or more, he or she engages in sexual intercourse with another person less than 15 years old, or it shall be an affirmative defense to this crime if the defendant was less than 4 years older than the victim at the time of the act. engaging in sexual intercourse with another person who is incapable of consent by reason of being mentally disabled or mentally incapacitated. Now, when they tell the story of Kenny messing with that mentally retarded person, okay, rape in the second degree, allegedly, but would have been appropriate. So, give me 1 second. Right. So I'm really just basically showing that the different crimes and the different rapes and the different definitions for these first degree, second degree, third degree, then you have sexual misconduct. You just have different levels. So why did they not choose any of those? If he was being railroaded by the police department and they just wanted to make an example or railroad another 16-year-old black boy, why did they choose rape? I just don't understand. Why would they go straight for it if he didn't do it and they didn't have any evidence? They have any evidence for it or anything. How would you just go straight to that? It doesn't make any sense. It does not make any sense. It doesn't make any sense. So the evidence that they have, we don't know. I've never seen what the rape kit, what the results, I don't know because I've never seen it. But Jen says that she went straight, she's always said that she went straight to school. The security guards seen her, what's wrong, what's going on. And she was immediately taken to the scene, showed Kenny and, identified him. The police locked him up and she was taken to the hospital. So I'm pretty sure there had to be some type of evidence. There has to be some type of evidence that showed that she was assaulted in that way. There's got to be some type of rape kit. There's no way that they just come out with attempted rape. You are not going to put that on someone. There are other charges you can use. You could use sexual battery. You can use all of these things. So then you add the knife being poked. I was just getting to that, DM Savage. You add the violence of it. And I know I'm doing a lot of talking, but I'm just trying to get people to understand. I hope I wasn't all over the place. I really hope that I was able to lay it out and take you down what I'm trying to show. There's no way that a person would just be charged with attempted rape. There is no such of a crime. The crime is rape. And attempted was slapped on it because of the plea deal. And that was to allow him to get less time. All right? That's the whole reason. Now, when you add on the knife was stuck in the stomach, the violence, all of the things that she described happening, that's why they arrived to rape. There was no other conclusion to come to. So once you're being charged with rape, the only thing to give you a plea was attempted rape. That's the only way to get the charges dropped down to a lesser punishment. They couldn't change it to sexual assault. They couldn't change it to certain things because of the level of aggravation, the level of violence, the knife, all of the different violent elements. That's how you know this crime occurred, because of the sentence and the conviction. There would be no way that he would be convicted of attempted rape in the first degree, second degree, or third degree was not the original charge. The original charge had to be one of those. It was not sexual battery. It wasn't sexual assault. It was none of that. It was either rape in the first, second, or third degree, which was dropped down to attempted rape. There is no such thing as attempted rape. Now, when I say that, I mean it is not written in the rule books or in the law books anywhere. It's not written in these crimes anywhere. The actual crime itself is the crime. Attempted, you can attempt anything. Attempted murder, attempted assault. They add attempted on it when they want to try to lessen the charge and repercussion. When a person takes a plea deal for murder, they lower it. You know what I'm saying? So there's different ways that the law goes about when they put that word attempted. And it's all to do with plea deals. Period. So it's obvious. It's obvious. She speaks about all of the violence and everything that occurred that day. I don't think someone would be that descriptive if that did not occur. And then he says it himself, that whatever it is that they went through, it was consensual. He said the sexual intercourse that happened that day was consensual. So you said in your brief, on one hand, that you did not have an encounter with her, but the encounter that you did have was consensual. You can't say in one breath that you didn't do it, and then on the other breath, come right back and say you did. But that's the typical, okay, well, if I did it, she wanted it. We had sex, but she was a willing participant. The knife stuck in the stomach, how is that a willing participant? If she was a willing participant, she would not have had to be cut. You wouldn't have to stick a knife in her stomach if she was willing. So there's certain elements, there were certain things that took place that day. There were certain things that took place during the crime, which constitutes being allowed to charge him with or in the first, second, or third degree. You take the plea deal, they slap it with attempted rape. Hello, Shrinking Sharon. They slap it with that in order to lessen the charge and lessen the punishment. Now, when taking these plea deals, like I said, I'm gonna give you one more receipt. When taking these plea deals and forming these plea deals, a lot of the times these attorneys try to work you the best deal. They try to work you the best deal. So why would they not work you out a deal where you would not get a punishment where you have to be on the sex offender list for the rest of your life? So now when we talk about attempted rape, they say, what is it? It's based on the definition of rape. Attempted rape is an attempt to have sexual intercourse with another person without that person's consent, where no sexual penetration occurs. So they're saying that if it's attempted rape, that no penetration would occur, that you attempted to do this, but you really didn't do it. So you just admit, wow. Now, you see how people, they step their own foot in their mouth, because attempted rape, you're convicted of attempted rape, right? You say you didn't do it, and your lawyer is trying to talk around this because he knows that people don't understand the law. He knows that people only hear what they want to hear. We hear the word attempted rape, right? So we think attempted must mean you tried to do something and you did not succeed. You didn't do it. And even in this definition of attempted rape, it says you attempted to rape someone and there was no actual sexual penetration. So that's why it carries such a less sentence, right? Punishment of attempted rape. Based on if you are convicted of attempted rape, you will likely face half the sentence for rape. Rape is a felony punishable by 3, 6, or 8 years in state prison and a fine of up to $10,000. Thus, an attempted rape conviction could carry a sentence between 1.5 to 4 years in state prison and a maximum fine of $5,000. Now you see this, right? You see why they had to drop it down to attempted rape? So that way he could get that conviction. But he just said in his brief that the sexual intercourse that took place that day was consensual. Well, if you've been convicted of attempted rape and there was no sexual intercourse involved, if they were allowed to give you attempted rape because you didn't have sexual intercourse, why did you just say in your declaration that the sexual intercourse that took place that day was consensual? There should be no sexual intercourse. So see, sometimes people, they put their foot in their mouth. They try to get these fancy smancy lawyers and they try to talk their way out of stuff, but really they put their foot in their mouth. So you want us to, I got convicted of attempted rape because they know I didn't do anything. They know I didn't touch her. No, they dropped it down to attempted rape because it started off as rape. With the violence that occurred, with the knife, everything that occurred. They had the rape kit, they had your DNA. All of this has been said. We don't have the documents because they were kids. So they dropped it down. When you did the plea deal, they dropped it down to attempted rape because they wanted to give you 1 to 4 years because you were 16 years old. So to get that type of sentence, they had to drop it down. So they said, this is what we're going to do. We know you raped this girl. We know you did these things because we have the evidence. But we're going to give you a plea deal because we don't want to ruin your life. You're 16 years old. We feel like maybe you made a mistake. However, we're still going to have you register as a sex offender. We're going to have you do that for the rest of your life because it was violent. It was violent. You had a knife. We don't know what you might be liable to do. We don't know what you might be liable to do as you get older. And then come to find out as he gets older, what is he doing? Killing people. He's still participating in crimes. So if this wasn't as serious as, people say, oh, it wasn't so serious, why is he has to register as a sex offender? Why does he have to register as an sex offender? Okay. So a lot of times you just have to do your own. That's why it's level 2, because it was violent. Exactly. And you have to, he's not just on the registry for 15 years. He's on it for his life. He's on it for the remainder of his life. He is not on it for 15 years. If it was attempted rape, like he said, he would have did his time, did his probation, and he would have only did the sex offender registry. I'll give the max 15 years. I'll give it 15 years. But not a whole lifetime. Not a whole lifetime. So I understand the barbs because honey, let me tell you what these people do to me. They come over here and they watch my videos about Tasha K. They love my comedy and they love my skits. But the moment they see that I have a different perspective on this case between the Pettys and Jennifer Hough, unsubscribe. So I might have got subscribers from Tasha K videos, but then as soon as I do this, I lose subscribers. So I don't have a personal interest in this like a lot of people because it affects my channel in a different way. People unsubscribe when I do these videos. Every time I do one of these, I lose subscribers because some people just don't believe Jen. Some people just don't like Jen. And some people do probably believe her story, but they're just barbs. And they just go down with whatever Nikki does because they are barbs. What I'm trying to get people to understand is This girl didn't deserve this, no matter whether, like, woman to woman, man to man, black person to black person. We need to do better. We have to stop allowing people to not be accountable for the shit they do. Nikki doesn't get a pass. She doesn't get to be a goon. She doesn't get to go on her social media and harass and victimize people just because she got money. Look how she did the lady from Trinidad. Look what she did to the lady from Trinidad. She got up there, gave the woman's phone number out, threatened her because she had a difference in opinion. Nikki is very, very, very narcissistic. When you do not agree with her, when you have a different opinion than her, she will go crazy on live. She will go crazy. Exactly. Why? Because he was young. That's the whole 16-year-old story. Because he was young. If they were trying to railroad him, they would have given him the maximum. Why did they give him a plea deal? They were trying to give him a chance. He was 16 years old. They were trying to give him a chance. And he still grew up to be a criminal. So if they wanted to railroad him, if the story is that they wanted to railroad him and that he was a poor black boy, they could have given him 25 years. They didn't have to give him a plea deal. They didn't have to lessen his charges. They could have left it at our first, second, or third degree, and he would still be locked up. They did not have to drop down the charges at all. So it speaks for itself. Everything that I presented today, it speaks volumes. The lawyer has put forth testimony, sworn testimony from Kenny, saying that the consensual sex between Jen and himself happened that day. It happened that day, and it was consensual. The consensual sex occurred. So you admitted that the sex occurred. The consensual sex occurred. Well, if it was attempted or there shouldn't have been any sex that occurred. So this is what I'm saying. Like, if you just got to read it yourself. You got to read it. You got to put the pieces together yourself, because it's obvious that this happened. It's obvious. Obvious that it occurred, and it's obvious that they're just trying to get out on loopholes. There's no way you're going to come back and say that, yes, I didn't do this, and it shows because I wasn't convicted of rape. I was convicted of attempted rape, which attempted rape means that there was no sexual intercourse. So if there's no sexual intercourse, why did you just come back and say that it was consensual? The intercourse, the sexual connection that happened that day was consensual. Wow. Your own lawyer just told on you. Your own lawyer. It's true. It happened. And this woman deserves retribution. If she wasn't able to get money back then, a settlement or anything now, by all means necessary, they should pay her. I feel as though she deserves every piece of money that she gets. If it was me, I would be doing the same thing. Oh, he got money now? Oh, he with Nicki Minaj? I'm going to go get mine. What's wrong with that? But see, that's y'all perfect ass people that try to come up here on YouTube. You think he coerced and then got violent when things didn't go his way with Jen? I believe exactly what Jen says happened. That she was, at the bus stop, and, they went where they went because he put that knife in her back, and he took her where she said he took her to. When she pulled up with the police, he still was there. Why was he there? What was he doing there if he had not just assaulted someone? They had, the weapon, everything. He's acting as if the judge doesn't have the power to look at the case. He's exposing himself. I mean, come on, just stop. All right. So that's all I got, you guys. He needs to be honest with you, this is the way I always say things should happen. People should just admit the shit they do, man up, boss up. I did the shit. I paid for my time, my crime. I paid for my crime with my time. I'm an older man now. I'm a husband. I'm a father. I'm with Nicki Minaj, and I have changed my life. I apologize to doing those things that I did back then. I was young and dumb. But Jen, I really do apologize. And to make your life better, we're going to give you here, we're going to settle, give you a few dollars, and we're going to stop. I will not allow people to harass you, victimize you, or anything. We going about our business, you going about her. What's wrong with that? What is wrong with that? What's wrong with that? I don't think it's anything wrong with that, but because this is not in his heart, that's how you're able to see that if this person was rehabilitated, like he says, he's been to jail, he's paid for his crimes. Is your attitude, why is this so defensive and repulsive? If you really aren't this way, why are you on camera throwing up gang signs and telling people, you see it, yeah, da, da, da. You see it, da, da, da. You see it, da, da, da. I'm going to kill some. Everything, your attitude and your aesthetic is like, I'm about to kill somebody. I'm going to shoot, I'm going to kill, I'm going to rob, I'm going to rape. I mean, what do you got? The rapper song, a lot of these songs is like you forcibly taking ass from women. So that's what this culture is, this rap culture, and the culture that Nicki Minaj, she lives with the rap, and, the women in the rap industry, they're allowed to be victimized and sexually exploited. So it's like, rape, that's a touchy subject because we are already allowing people to be sexually exploited. We already telling women that they don't need shit. Sexually, we could just have our way with you. We could have our way. We could get it when we want it. Give me head in the bed when I say it. Give me head in the bed when I say it. On my nose, on a pole. Give me head in the bed when I say it. On the pole, on the roll. You better suck this dick, bitch. You better suck this dick, bitch. I mean, it's already like, that's what it's given. Women are supposed to do what I say. Get on your knees. Let me pull it from the back. That's the culture. You got a woman, you accusing him of rape? Oh, hell no. So if he was such a great figure in society, all these barbs and all these people that all of a sudden care, oh, he's a black man that did his time. It's because it's Nicki Minaj. If it wasn't Nicki Minaj, y'all wouldn't give a damn. Y'all would not give a damn. Y'all would be like, that bitch deserved that money. But it's because it's Nicki Minaj, and it's because y'all just love her. You don't care about a woman. You don't care about her being a victim. I feel as though he did this shit back then. She deserves money. If she couldn't get it back then, I feel as though give it to her now. Shit, I would be doing the same thing. You did this to me all these years ago. I tried to let it go, but you keep harassing me. You keep sending people on my phone. You keep popping up at my door. You keep sending people to try to make me recant my story. Leave me the fuck alone. You're not going to pay me. You're not going to give me no money. Leave me alone. I would do the same thing. I would be doing the same damn thing. You know what? I'm suing y'all, and I'm going to try to get as much money as I can for my pain, my suffering, and my motherfucking time. Period. So I just don't see anything wrong with it. I don't see anything wrong with a person wanting retribution, with a person wanting to be paid for their pain and suffering. I really don't. A lot of y'all fake car accidents for car insurance money. A lot of y'all get in car accidents and know damn well your neck ain't hurt. They hit the back of your car, but your neck is hurt. And go to therapy 40 times just to get $10,000 2 years later. A lot of y'all do that, but you want to talk about a woman being raped and that she should just let it go? No, I don't think so. I don't think so, papi. I'm with Jen. Sue, get your money. Shoot. So this has been another edition of the Sweet Pea Diaries. I'm going to get up out of here. I got to go and get ready for the second video, child, Tasha K. I have a major update with this girl. She just doesn't stop. She will not stop. She is so desperate. It's like we are at the finish line, child. This is a desperate attempt. Last desperate attempt. Yes, I'm here for the message. Says, do you think the photo yesterday was to prove that the service processing was botched? Yes, I do. I think that the photo, they were trying to really look not like themselves, to try to make it look like, how could you describe Kenny as 200 pounds? He's little and thin, because the description of Kenny, that photo did not look like Kenny. You know what I mean? But just stop it. We know that the man served you. You know you were there. You know you saw him put that damn notice in front of the door and say, I'm leaving it here and I'm walking away. But that's just how lawsuits go. You guys know that if you pay someone to try to get you off, that's what they're supposed to do. I cannot fault them for that. Same way I can't fault Jen for wanting her money. Same way I can't fault Nicki Minaj and Kenny for trying to lie their way out of it. If you're going to say that, you served me, well, it's my job to prove that you didn't. And if you didn't put that in my hand, then oh shit, I'm going to try to get off one. That's just the way it goes. But see, I'm real enough to admit that. Just because I side with Jen doesn't mean I can't see both sides. I do stand for Jen, and I do, agree with her stance, and I believe in her story. But child, it don't mean that I can't tell the truth in what I see. Yeah, they trying to get off on that you didn't serve me shit. And it just might work. It just might work. So we'll be coming back in about another hour, probably about another hour and a half. I'm going to have to change the time because I have to go I got to run out real quick and go grab something from the market. So I'll probably be live about 9:30 with this Tasha K update, child. So you guys be sure to like this video, share the video, but most importantly, be sure to subscribe to the channel. And I'm out. I'll be back in an hour and a half.